My name's Patrick Gould. I'm a Qualcomm Fellow here at Harvard Law School and part of the project on the foundations of private law. I just want to make a couple of announcements before we get going. First of all, we are webcasting this event, and we are, except for panel 4, recording the event. So any comments you make will be picked up on the recording. To make comments in the Q&A, you'll see the microphones at either side. So we're going to be in here all day, except for our breaks. Food will be served in Milstein A there. So feel free to flow back and forth. And the only thing I should say then is thank you to our sponsors, Qualcomm, and also thank you to Harvard Law School and to the University of Texas Law School for making this happen. So now I will ask Dean John Manning, Professor of Law here at Harvard Law School, to welcome you formally.
So welcome to this fantastic conference. It's the Administrative Private Law Interface in IP. It has lots of things that I find interesting. Administrative law, private law, IP, and how they fit together sounds like a good way to spend a day thinking about things. And it's a great lineup. I'm very glad that it's here. We have a strong and quite varied intellectual property faculty, but this is also the home of the new private law. And it's also one of the places where administrative law was born, and so I think it's particularly appropriate that this conference should take place here. As I've said at several other conferences, part of my job is to open conferences I can't attend, and today is no different. Today looks very, very interesting. I wish I could be here to hear the panels. What I can do is say thank you to all of you for being here, and to thank in particular Henry Smith, John Golden, and Patrick Gould for organizing this wonderful conference. And to say have a great day, mix it up, advance human knowledge, and have fun. Okay, thank you very much.
So thanks for coming out. My job is just to introduce our first of two keynote speakers who will bookend the substantive sessions for today. And our first speaker is the Honorable David Kappos, who's now a partner in private practice at Cravath, but most relevantly for the proceedings today is, as many of you know, the former or a former director of the U.S. Patent and Trademark Office during a time in which we had a number of very significant developments in terms of the administration of patent law. And before that, he was for many years, if I recall correctly, the sort of head of sort of intellectual property at IBM, a private firm that's been one of our leaders in patenting for many years. So with that, I'll just turn it over to David. Thank you.
Okay, good morning. Well, thanks for the introduction. It is a real treat to be here with you at Harvard Law School for another one of these great sessions plying the intersection between intellectual property and other domains, including, in this case, private law, administrative law. Let me start by letting our staff adjust the materials and saying thanks to Henry and also to John and Patrick for continuing this kind of a dialogue. I think this is an incredibly important discussion to be having for reasons that I'll mention substantively in general and particularly right now. And with all that has happened to the administrative law, private law interface in the last generation, it is perhaps, high time, if not at least time, to step back like these folks have helped us convene in doing today, and ask some questions about, what's going on here, and is this the right balance? And I'm just thrilled to be able to just sit in the room and listen and absorb all of it today. So, Henry asked if I would make some sort of opening framing remarks. And to do that, what I thought I would do is a couple of things to go back over briefly, because we all know what happened, but sometimes it seems like it's good to just step up and recount how we got to where we are. And I'll do that, and then I'll talk also a little bit about recent changes and what they seem to be pointing to, and then some other what I would call big picture demographic trends that I think are going to potentially dramatically impact this administrative law, private law interface, to try and set the discussion up today. So I will leave it to the panelists and their moderators to explore many of the topics that will be discussed in detail. But what I'd like to focus on a bit is start with where the U.S. IP system in particular has been in recent years, and why we did the things that we did, and we've done the things that we've done over the last generation or so. And to do that, I would say, recall about 10 years ago, there was, widespread belief that the IP system, at least in the U.S., was broken. That was a term that we used a lot. We concluded that it was too strong, that the patent trolls were out of control, and that narrative really took hold, and it became a dominating force in policy making. And courts and legislatures and the U.S. Patent and Trademark Office heeded those concerns and acted in response. And there were then a series of cases in the last 15 years that dramatically, especially went at the Supreme Court, that dramatically and repeatedly cut away at the strength of the patent system. And I won't go through them in any detail, but I'll just recount them. It's almost dizzying to remember everything that has changed. There was stopping of automatic injunctions in patent infringement cases. That was the eBay decision. There was reframing the non-obviousness requirement in a way that made it more difficult to secure patent rights or to maintain them. That was the KSR decision, also at the Supreme Court. There was altering the indefiniteness standard for patentability by creating this reasonable certainty test. That was the Nautilus decision, also at the Supreme Court. There was making it easier to award attorney's fees, and we didn't just get one Supreme Court decision for that one. We doubled up with both the Octane Fitness and Highmark decisions. And I'm not trying to go through everything. Then there was just last year the holding that the patent exhaustion doctrine, which of course precludes patent holders from enforcing patent rights after a product has been put into the marketplace. We learned that it automatically applies and it can't be circumvented even when the patented item is sold outside of the U.S., and that was the Supreme Court's Lexmark decision. So I would tell you, I don't quarrel with most of those decisions. In fact, I think most of them, I strongly disagree with the Lexmark decision, but I think most of the others I tended to agree with. So it wasn't, in my view, it wasn't that the decisions were inappropriate, but it certainly is the case that we have dramatically rebalanced the U.S. patent system in response to our belief, a belief that I shared in large measure, so again, I'm not trying to put this on others, that our system had become too strong and too subject to abuse. But I'll tell you, whether you agree that the previous decisions were good, the system was too strong, it was too subject to abuse, whether you agree or disagree with any of that, what has befallen the area of patentable subject matter, what we refer to as Section 101 of the Patent Act, in my view, and I think it's fair to say in the view of many others, approaches an actual tragedy. This hasn't been good. It's been very bad. And in this area, the Supreme Court has, through a series of decisions beginning in 2010, the first of which we fought against vigorously at the U.S. Patent and Trademark Office, and were frankly able to get the Department of Commerce to back us up in, for the first time ever, not signing on to a Department of Justice brief in the Supreme Court on a patent case, and that was not by accident. It wasn't that we were sleeping. It was that we refused to sign on to it in what was meant to be a vivid example of dissent within an administrative law state. That decision, followed by a series of others, has, I think it's fair to say, severely constricted the U.S. patent system scope. And so there was that set of decisions from the court, but at the same time, federal lawmakers and even state lawmakers were busy at work scaling back the patent system, largely in response to the same concern about patent trolls. The system's too strong, it's too subject to abuse. And most notable, of course, as has already been mentioned, was the America Invents Act of 2011, which you probably won't be surprised to hear, I think was generally a great piece of legislation and an example of the administrative state moving in a direction that was needed and helpful for many very practical reasons. But among the changes in the AIA, it established this very muscular new administrative law overlay on the concept of patents as private law rights, with this post-grant review system that provide us with these very robust opportunities, not one, but several opportunities to challenge and indeed invalidate patent rights that had been previously granted without ever having to go in front of an Article III court, but instead within the very same agency, the USPTO, and its Patent Trial and Appeal Board that had granted the rights in the first place. State legislatures, for their part, have been busy with their patent troll concerns also. Most U.S. states, if you didn't know this, have individually passed legislation, so we've got an incredible patchwork quilt now that's extremely hard for good faith patentees to navigate, because they've all passed their own, most of them have passed their own legislation that creates what they refer to typically as tough rules to stop patent owners, and to force patent owners who want to send demand letters against infringers to specify with great particularity what their issue is in those letters. And again, whether you agree or disagree that more specificity was needed, you have to know that this all puts downward pressure on the patent system, because now if you're a patent holder and you want to send out a notice letter, you've got to have lawyers who can look at the laws of 30-plus states to figure out if you're compliant with those laws. So again, much of this is good, but together it's fair to say a lot has been done. Now, although those changes that I've just discussed were primarily internal to the IP system, they were about the agency that grants the patents and the courts dealing with them, there was a very comprehensive set of challenges that have come about in the IP antitrust interface. I know a topic that'll be discussed a lot today. And what we've seen from that evolving balance, as you could see, I would say increasingly imbalance, is that antitrust regulators in the US and around the world, frankly following the US, have become increasingly hostile towards the perceived anti-competitive nature of patents. And so if you sort of go into that in a little bit more detail, you'd have to say the focus has been on standard essential patents, of course, where there's become a belief that patent holders tend to commit abuses in exercising their patent rights in the context of standards. And this is an area where the administrative law, private law interface, in my view, has dramatically shifted and has shifted in a way that generally is not very helpful. So, of course, the U.S. patent system's basic premise stems from this constitutional grant of exclusivity, what has been called by the Supreme Court a legal monopoly to invoke the state's power to prevent others from utilizing a discovery without the inventor's consent. So we've got a long history that says this whole patent thing is just okay, it's perfectly fine, and that was all around more than 100 years before the antitrust laws came around, and we seem to be able to navigate that intersection pretty well for a period of time. But what's happened more recently, in a resurgence of this notion that patents are anti-competitive or cause anti-competitive behavior, has been antitrust law and intellectual property viewed as being in some way inherently and fundamentally incompatible. As I said, the tension isn't rooted in doctrine. The Supreme Court has historically made clear that the possession of the whatever monopoly powers associated with a patent, if any, isn't unlawful, but it's the accompaniment of that power with anti-competitive conduct that creates problems. Unfortunately, what's happened is there's been, in my view, a terrible conflation between these concepts and a lack of appreciation of the time frames that these various tensions operate on. To be more specific, the consumer benefits that are more apparent to antitrust regulators and that animate consumers' view of the system tend to occur over short periods of time, whereas the effects of the IP system tend to occur and be felt over much longer periods of times. And that then leads to a tremendous lack of appreciation for the importance of innovation incentives versus the importance of the role of the consumer and price actions that occur in the shorter term. And it's led to this temptation to seize on this seemingly undesirable set of market outcomes and then draw on antitrust principles and the concepts of static competition that are attendant to them in what has become a kind of an agenda of using the antitrust laws as a vehicle to weaken the IP system. Even if that perhaps wasn't the original motive, that certainly has been the effect. So it's a battle between the administrative law state and the private law state, very central to this conference, and I know we'll hear a lot about it as the day goes on. But I would tell you that what hangs in the balance, right, isn't just these battling parts of a government infrastructure, but what really hangs in the balance is innovation incentives and long-term prosperity of our economy and, in fact, the global economy, since so many other countries follow the U.S. in this regard. And it's through this lens that standard essential patents, frankly, became viewed globally, in my estimation, as Exhibit A for antitrust regulators seeking to correct, to use that word, what they viewed as an IP system exceeding its proper bounds. So the administrative state making tremendous incursions into private law through an antitrust vector. Their belief was fed by these then popular memes, if you will, of SEP friction with antitrust, namely through the forms of what we've come to know as patent holdup, royalty stacking, and broken FRAN norms. And what we have experienced in the intervening period is that we have found through great academic literature by some people in this room, many others in the legal domain, as well as economists, frankly, all over the world, we've learned that these theories, hold up, royalty stacking, et cetera, that sounded extremely plausible when they were first invoked 15 years ago, we've now got intervening data in important industries. And economists and lawyers, as I said, are writing on this subject and analyzing the data. And the data has shown that there's absolutely no evidence that any of this stuff actually occurs. And the courts have started catching on too, particularly in Europe where they're asking hard questions, and even in some good cases in the US where jurists have said, just alleging this stuff occurs and that therefore there's an antitrust violation kind of isn't good enough. You need to show me some evidence, and you guys don't have any evidence. But yet concerns about these phenomena and the frictions that they were thought to have caused persist, even counterfactually. And there's been this set of erroneous concerns that have infected the global discussion around IP and standards, and again have spurred antitrust regulators to take action in the US and all over the world. An example of that is the administrative law state here in the US through the Federal Trade Commission, initiating proceedings on the theory that merely threatening or seeking an injunction or an ITC exclusion order can constitute a violation of Section 5 of the FTC Act. This came to fruition and started to become a major issue in about 2014 when the then chairwoman of the FTC declared, quote, "In the standard-setting context, the risk of patent holdup creates the type of competitive harm that falls properly within the scope of antitrust enforcement." So this is the administrative law state very clearly saying, we want to proceed based on a theory. It turns out we found out that theory doesn't play out in reality, and we're going to go and regulate private property rights based on that theory. Another example, the former head of the Department of Justice, Antitrust Division, contemplating the merits of imposing antitrust liability, not only against SEP holders who act deceptively in the standard-setting process, but even against those who purportedly violate FRAND commitments, including through seeking an injunction. So again, you see really strong reach-in from the antitrust regulators through their administrative posts over into the private law area of patent rights. Similar trends, of course, playing out abroad. Everyone watching and following the moves of the DOJ and the FTC. And so you saw the 2014 amendments to the Korean Fair Trade Commission's guidelines for review of unreasonable exercise of IP rights, including broadly defining what constitutes abusive action by those holding SEPs, and then the KFTC subsequently taking aim at SEPs more directly and holding that it has the right to dictate global, not just in Korea, but global licensing norms and rates for standard essential patents. So the situation has just gotten further and further and further out of control. Now these administrative law incursions into private law rights, it turns out, actually aren't even just limited to patents, and I hope we'll talk about this today. The example that comes to mind for me is the DOJ also targeting the copyright area, as highlighted by its stance against performing rights organizations. For those of you who follow this area, as you know, PROs like ASCAP and BMI and CSAC aggregate IP rights of their members, music copyright interests, individual contributors such as songwriters and publishers and the like, and they offer these nice blanket licenses. They've long been regulated by antitrust consent decrees, but it's been found that their blanket licensing enables licensees like television and radio stations and the like, now internet broadcasters and restaurants, to get the rights that they need in order to do the things that they need to do, put music out into the marketplace, and so that their work was thought to be okay. Then in 2016, as the administration's outgoing, the DOJ suddenly drops this bombshell in unexpectedly taking the position that the consent decrees under which those pros had operated for literally decades prohibit the long-standing licensing practices that those pros had been using under their consent decrees, again, for decades and decades and decades. And under the DOJ's view, it was suddenly declared that these co-creators, members of different pros, right, would be unable to license their partially owned works. The works would become completely unlicensable and stranded. And of course, the intention was that it would cut the bottom out from under the marketplace, because if there was no other alternative, people would give up and they'd essentially give their works away. Fortunately, we have had adults step in. ASCAP and BMI did not step aside and stand still for that, and I'm happy they didn't, because that resulted in lawsuits, which resulted in the overseeing district court, and then, if I recall right, the Second Circuit telling the Department of Justice Antitrust Division, frankly, this is insane. You're not going to get away with this. I know, Henry, we're on the record, so I'm stating things as accurately as I can, that the Department of Justice doesn't get to just walk away from these decrees that have been in place and the work that these pros have been doing all these years, and the administrative law state doesn't get to just overturn private property rights. So I was very happy to see that turn out the way it did, but it marked to me another major incursion. So how has all of this impacted IP policy? What I would tell you is, whether it's the weakening of the U.S. IP system or antitrust regulation around the world, or whatever it's been, a once healthy ecosystem at a number of these intersections, primarily, and I would say centrally, this innovation deployed through standards intersection, a once healthy ecosystem has become, frankly, under siege. I would tell you, not necessarily, and I think there's some good signs of change that inform us that we don't have to settle for a retreat that would be caused by this continued siege to depressed levels of investment in innovation and depressed levels of investment in standards, and that we're seeing signs of policymakers in the new administration stepping in and taking a different view. I would also say that leadership in innovation policy means that administrative law requirements have to recognize the tremendous risk that innovators take, and the regulators coming from the antitrust side need to have a better appreciation of the pressures on the innovators, not just the pressures on the implementers. Innovators make massive investments in R&D, much of which fails. They do so under relentless pressure from market-based forces, because, of course, there are always alternatives. Until a standard is set, there's standard alternatives, there's non-standard alternatives. And then once a standard is set, everybody gets to use it and compete in the marketplace. So for the innovator, there's absolutely no possibility of feature differentiation. The only way to recoup the investment that's been made, if it turns out to be successful and if it gets standardized, is through royalties. So the whole system winds up becoming extremely unstable for the innovators and for their sustained investment, unless there's a recognition and the administrative state can appreciate the pressures on that side of the equation. Of course, naturally, the implementers have valid points of view too. They want to acquire standardized technologies at the lowest possible cost, and that's good and perfectly fine, but this desire has to be squared with the sound policy of incenting innovation and contributions to these kinds of standards. So said differently, the administrative and private states need to come up with a better balance that recognizes the legitimate interest on each side of the equation. I view that the risk is that if policy is guided by only one perspective, whether it's the implementer's perspective as it has been in recent years, or whether it's the innovator's perspective, it's not good. There needs to be a full appreciation of both perspectives, and a balance has to be sought. I would tell you, though, that while there's risk of imbalanced solutions if either side is favored and both sides aren't taken into account, there are signs that we're moving in a better direction now. The tide is turning at the Department of Justice. For the first time in history, if you haven't heard this already, the DOJ's top antitrust attorney is also a registered patent attorney. So we have a patent knowledgeable expert lawyer running our nation's antitrust agency. I think that is a great thing and a great way to promote balance. Since his appointment last September, he, of course, you probably know, has stated publicly and repeatedly that previous antitrust policy, quote, strayed too far, end quote, in protecting the interests of implementers at the expense of innovators, and, quote, the process of dynamic innovation itself, so, end quote. So there's recognition of a couple things. We lost balance in a direction toward implementers. We need to reassert that balance. And number two, dynamic competition is important. The competition brought about by disruptive change through new technologies is really important, and it inures to our long-term best interests. Coming off of that, there's been a broad coalition, including judges and academics and economists, et cetera, who've signaled their support for his comments, counterbalancing an array of others who've signaled opposition to this change and desire to have the administrative state keep doing what it was doing under the previous administration. And then since then, the DOJ has advocated what is being referred to as a, quote, new Madison approach to setting antitrust's role versus intellectual property, premised on 4 principles that emphasize the limited role antitrust law should play in the context of areas like standard essential patents and the importance of innovation incentives and the legality of patent holders' refusal to license valid patents. So lots of change, definitely moving in a direction toward a reassertion of the importance of private law norms and the private rights brought about by a patent system. And the thinking out of the DOJ isn't alone. Other officials have made similar calls, including in the US and overseas, as recently as right on the eve of the Olympics in Korea, in a speech in front of KFTC officials. So you're seeing a rather dramatic change on the part of our own antitrust enforcers here in the US. And I would also tell you that while the antitrust folks have been at work resetting this balance, there are new technological trends that I believe will test this boundary between administrative law and private law in a way we have never seen before. And in this regard, I'm referring to what I think is an absolute juggernaut, which is the onset of blockchain technology. I know folks in this room are studying this phenomenon. People get it confused with Bitcoin and Ethereum and currencies and initial coin offerings and things in the financial services marketplace. And blockchain does play a role there, but I would tell you that the financial services part is the tail wagging the dog. And what's really going on with blockchain is a fundamental reordering in which we now have, for the first time, a native digital vehicle for the transaction of value, and that is very fundamental. The internet was our first native digital vehicle for the sharing of information. Blockchain is a native digital vehicle for transaction of value. When people transact value, the stakes get very high very quickly, and people care an awful lot about it. And what we're seeing taking place in the commercial area, and I see this vividly in New York and in my day job, is dramatic, important projects that are going to potentially move from government control and oversight important activities into the private sector. Everything from identity verification and identity control all the way over to intellectual property, where there's very clear moves afoot to marginalize areas of intellectual property, including the patent system, and potentially transfer large amounts of those kinds of areas of law into individual private ordering through blockchains. Not saying this is bad, but it is really important. And this is why I feel a conference like this one is critical. We are going to see in the next 5 years, certainly in the next 10 years, dramatic movement of government function towards private ordering through blockchain. This anachronistic, almost, if you will, almost impossible combination of transparency and confidentiality, of anonymity and accountability, of this immutable ability to track everything suddenly in a way that enables dramatic changes in the way we order our affairs. And in my estimation, it will affect this administrative law, private law interface very centrally. So I hope there'll be more consideration of those kinds of topics, because I think when you put the work that DOJ is now undertaking, which I think is moving in a good direction, other calls to redouble, re-strengthen the intellectual property system and private rights, and then you lay on top of it dramatic technological change through blockchain, we've got a whole new world facing us. So to conclude, these recent developments, in my estimation, demonstrate that there's a lot that's moving in the last year or so in a positive direction, and that there's a recognition that good policy calls for good balance, and balance between the interests of all parties who are contributors and participants and stakeholders in our systems. Private law, administrative law has that same requirement and that same sense, with those who are users of rights having their interests and wanting to decrease their input costs, and those who are creators of rights having their interests and wanting to receive an adequate return on investment. What's going on is a demonstration of an increased recognition of the need for a sharper boundary between private and administrative law, and a limit on, particularly on antitrust breach of that boundary between it and the IP domain. So I'm hoping to be able to listen to the panels that follow today and contemplate ways that we can continue to promote, in some cases restore, in other cases enhance, whatever word you want to use, the proper balance of interests, and respect this boundary between private and administrative law, so that we can have policies that recognize and champion innovators' efforts in addition to implementers' legitimate interests, and foster all-important innovation so that we can have more opportunity and more progress in the future. And with that, I'll say thank you very much, and I'm looking forward to the conference.